Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney. I want to talk to you today about how I approach cases with a client who has multiple medical problems. And I mean maybe 7 or 8 medical issues. There could be knee issues, diabetes, vascular problems, mental health issues, cardiac problems, orthopedic problems. It could be a laundry list. In fact, I recently had a case where my client had about, I think, 9 different medical conditions, all of which he was getting treated for. And what I do in those situations is I really try to focus on 2, maybe 3 medical problems that are the most severe. And the reason for that is that if I'm trying to present 9 different medical issues in a 45-minute hearing, and these hearings in disability typically last about 45 minutes, I'm going to get the judge confused, and a confused mind always says no. So what I'm going to really focus on are the 2 or 3 that are the most significant in terms of vocational limitations. Remember, Social Security is about your capacity to work. So you may have a lot of medical issues, but ideally, from my perspective, 2 or 3 of them are going to have really significant vocational problems. For example, if you have mental health issues, depression, anxiety, schizophrenia, that may impair your attention, concentration, focus, memory. Those are work issues. If you have diabetes with neuropathy, that may affect your grip or your balance or your ability to stand and walk without a cane or a walker, something like that. It could affect your vision. Those are work problems. So I'm going to focus on that if your diabetes is severe enough. And typically it's going to be insulin-based diabetes as opposed to just the diabetic pills before I'm going to focus on diabetes. So that's the way I look at it. If I have those 9 or 10 conditions, what I'll probably do in that case is write a pre-hearing brief where, again, I'll focus mainly on the big 2 or 3, but I'll mention all the other ones so it's part of the record, but I'm not going to spend a lot of time at the hearing about that. And if you start to wander at the hearing and start to talk about all these different things, I'm going to cut you off, because what I find a lot of times is that some of the less significant medical problems, even though they may be important to you, there may not be a lot of medical development on them. So if there's not a lot of medical development, I'm not going to put a lot of effort into it. But I will tell you from experience that if you try to bring up more than 2 or 3 significant medical problems at a hearing, the judge is going to get confused, and you're probably going to not have as good of results as you would if you focused basically just on 2 or 3 with really significant medical issues. So that's kind of a trial strategy that I use. I found that's been fairly successful, and again, that would explain why if you have an attorney like me, that the attorney doesn't cover everything, even though he may want to mention it in a brief, because it's usually more fruitful just to focus on the 2 or 3 things that have the most significant work capacity implications. Hope you found this helpful. Again, I'm Jonathan Ginsberg. If you like this, please give it a thumbs up on YouTube, like it on Facebook, share it on social media. Any questions or any suggestions about future videos, I'd love to hear from you. So until next video, I will be talking to you.